Okay, I just wanted to check in with you all and try to bring into context the next kind of section of the work we're doing, and kind of what that was related to in weeks 1 through 3, and then going into week 4 is really kind of where I'm hoping you'll start to bring it together. Um, I'll give you an idea of kind of where everybody's at. Um, there's 58 students in 2 classes looking at the same kind of subject matter. And so that can be a little bit challenging, right, for me, simply because you're all at kind of different places. For the most part, you can get ahead with the exceptions of the quiz. You can take, some of you have already taken the quiz, so you can take the quiz, but I can't really get feedback to you until a little bit later. And then also, I think, something to think about is just it can feel it can feel like a good idea to try to do this on your own. And in my experience, a couple students are able to do that. But when you're trying to think about it within the larger class, that's when you're going to have a better experience, especially a class like law. Law is not like biology. Yesterday, I was having a conversation with a biology professor about evolution, right, and the kind of the wrong ideas students have about that. There's a lot of similarity to that between biology and law. So I want you to think of this class more in that way. With that said, let me just try to get to some basics, and there'll be a bit of a quiz review here, as well as just kind of a recap of what we've done so far. So I just wanted to start off with this kind of madness, if you will. So I want to start over here on this left-hand side. And, in a nutshell, what I'm trying to get you to see is the process of decision making that lawyers and judges create, which is different than everyday folks. So this process is called abduction, and it has 3 parts. So basically, there's a rule, there's a principle, and there's stare decisis. The rule is something that's been established by courts over time and has one of 2 sources. Either it's from positive law, which is the legislature or Congress. There's a rule or a law that's been passed by government, and many of you understand that that was signed by a president. What I'm hoping that you'll start to understand is that most of the laws are actually passed at the state and local level, right? So New York City has a policy, that's different than the New York state policy, and then that's different than the federal policy. And that's a concept called federalism. The other source of law is more complicated and more philosophical, and that's the natural law. But it seems to be what a lot of you believe in already, and that's self-evidence, meaning that we're all equal, right? That's a self-evident concept. That's not a legislation. There's no congressional legislation that says that. So that's something that you want to kind of keep in mind as we move forward. The other idea that you probably want to keep in mind is this general kind of concept this general kind of concept that would be related to where do you get your sources of laws, right? So I want you to think about this as the institutional form of laws, because depending on whether you're looking at it from a natural law, the self-evident point of view, or whether you're reading and translating legislation, is going to uniquely influence how you apply the rule. I'll come back to this. I don't need you to necessarily know the difference between those two things. What I need you to know is that just because you apply a rule one way does not mean that all people will apply the rule the same way. And that's really the main thing I need you to start understanding in the next couple of weeks as we move to the harder part of this course. We then have to examine this concept of principle, right? So a principle is a pattern that emerges from the cases, whether they're from positive law or whether they're from natural law. As a point of trivia or something that we would like for you to have learned in another class, natural law was the most common form, both for lawyers, judges, and ordinary folks, until about the middle of the 1800s. So for several hundreds of years, this was kind of the way that people made sense of the world. And we normally call that custom or habit. In the late 1800s, with the concept in American government that you'd call Reconstruction, following the Civil War and following the ban of slavery in the West, with notable exceptions of imprisonment and conviction, judges started to be more open to the idea of a legislature making rules that people could follow. And that seems to be where a lot of you are getting the idea of law, right? So you're picking up on this feeling of judges, especially in about the 1930s, they start really bringing this new way of thinking. So less about natural law, less about self-evident law, and much more about, well, what did the legislature say? So judges are always suspicious when somebody interprets the law in a way that is beneficial to them but harms someone else. And so if a police officer is saying, well, this should apply to me, but it wasn't explicitly written into the legislation, then judges are most likely going to say that, well, that's a wrong interpretation or wrong application of the principle. So this is known as the arbitrary and capricious standard. I will kind of get into this more often. But you should be aware of this general principle, that judges don't like it when folks kind of take things on their own and aren't doing exactly what the legislation said. The most famous of these judges was Justice Antonin Scalia. But he's really only emphasizing something that's a common practice. Then there's this conclusion, right? And this is what students tend to follow before they get to this class. So if you think of something like separate is never equal, that's a conclusion. That's not part of the rule and that's not part of the principle. So this is complicated, and this is the most complicated part of the course and the one that I think you're going to have the hardest time with. But this is the process by which the principle and the rule applied to the particular facts of the case. And so what judges must do is they have to situate their decision within other decisions. So they can't do something that only they have done. Or another way of saying it is they can do that, but they are very likely to be overturned as a matter of law at the appeal stage. And so the practice is, and what you learn in law school, is to frame your conclusion within what's called a rule paragraph, where you will have several rules that you're now applying to a particular conclusion to say, this must be the answer, right? Because this is what courts have done for a long time. The rule against prohibiting gay marriage was constructed this same way. The same thing with Roe v. Wade, that the rule was really a compilation of many rules. So let me apply this, right? Because what you've done so far, which is what this box is just kind of like, I want you to see the difference between the judicial making process and kind of the legislative making process, or politics in general, and how that's even different than, say, media. So the rule in this case, right, if I were the judge, I would say, look, a judicial warrant is required, right, period, end of story, unless there's some exigent circumstances. Those rarely apply in a home or a corporate setting. Exigent circumstances most often apply in the public or in a car stop, right? So either it's a pedestrian, right? The police officer comes up to a person and they've got exigent circumstances, like, the plain view. Or it's in a car stop and where they fear for the life of their fellow officers or themselves or some public person, and what they usually label as a furtive movement, right? So the person moved in a way that caused them to be suspicious. So those are the exigent circumstances. Those rarely apply in a home or a business office. So even in that circumstance, if you could come up with this exigency or emergency, that doesn't mean that evidence is going to be used in trial. That just means that, put this simply, the person who was the victim of this wrongful seizure would not be able to sue the police officer, in a separate claim, right? So I just want to, the rule is, if you want to remember this, right? The rule is no warrant, no good, right? That's very different than the common understanding, right, of what ordinary folks think. And, Jay-Z's song 99 Problems, right, doesn't seem to understand this concept, although he is obviously willing to fight the case, as he says in the song. But the rule is, from the judicial point of view, from the legal point of view, no warrant, get out of here. I don't even need to talk to you. So what's the principle behind that? Well, the principle is, it's been long established that United States citizens have a zone of privacy. And there's multiple cases. I just cited three that are the most famous cases: Griswold versus Connecticut, Pierce versus the Something Sisters, and then Lawrence versus Texas. These are just three big cases that people tend to refer to, but there must be 1,000 cases that have talked about this. Now, corporations have been determined as legal persons in Citizens United, so they therefore also hold Fourth Amendment protections. What does this mean? Well, look, there's a series of cases that would argue that the case against Amazon should be dismissed, right? We'll see what happens. Cases move slow. Most likely Amazon will settle, to be honest with you. But there really isn't enough evidence from what I gave you and from what Attorney James has put forward to either prosecute Amazon or to sue them in civil court. And so any judge would have a hard time not dismissing this case. Let me pause for a second and let you think about that, right? Because almost all of you said, what, right? You want Amazon to be held responsible for what they do. So that's this black side here. I need you to understand, like, law could be an ideal, but it's not, right? We're human beings. So if law was an ideal, there'd be some higher authority that decided what the law would be. It would be based on some kind of idea of morals. There'd be seamless control, meaning that anyone who doesn't abide by the law would then be punished immediately. This would, of course, serve as a deterrent, so people wouldn't want to, step out of line. Everyone would understand the law. Everyone would benefit from following the law. There'd be no corruption, and humans would be angels. So this is not real, right? This is not even remotely. This isn't even a good movie. You need to understand the difference, right? So law is experienced, right? Many of you have situations in which there is no way you could tell a police officer you violated my Fourth Amendment rights. Okay? I'll get into this in the extra credit sessions, but stop and frisk leads to wrongful convictions. right? So if you don't understand that, then you're not understanding the Fourth Amendment as really experienced by human beings. You're thinking that everybody's doing what they're supposed to do. Nobody does what they're supposed to do, let's be honest. Law is not made up by a higher authority. It's not dropped down from a mountaintop. It's made up by groups, and it's largely made up to benefit the group who passes the law. This means that it's not really based on morals, right? That would take so much time. I mean, imagine if I wanted to just understand the morals of all 60 of us, right, in this class. How would we even start that process? There's going to be things we just totally disagree on, and then there's going to be things that, we understand, but we understand it differently. So, for example, a lot of you want to get feedback on every single assignment, but I've been teaching for over 10 years. Less than 5 students out of the 60 will complete every single assignment. So in theory, those students would get the C. And then purely by not finishing the other assignments, everyone else would fail because you didn't finish the coursework, right? So that can't be the rule, right? Because the principle would be violated, right? The principle is probably more something like, well, I was able to understand the content even though I didn't complete every assignment. That's the principle, right? Because that looks at all the different cases. So that's not the rule as ideal. That's rule as really experienced, right? This is how it's really actually going by actual people. So a law is mostly made up by whim or belief, right? Some person or some set of people in a group decide that this is what we think is going to be the right thing, but it's not set in stone, and it's definitely not a scientific truth. It's more of like an experiment. Let's see what happens. The other thing is there's no actual control, and any law enforcement officer will tell you this. You can pass any law you want. That does not mean that the police officer is going to be able to say, listen, buddy, you're violating the law, and then that person gets it. So deterrent doesn't really work there either. So what are we really doing? We're doing kind of a warning system, right? Saying this is what the government cares about right now. Don't do this thing. And if you thought about the policy towards marijuana, right, in recent years versus 30 years ago, you can see the government is less interested in that. So it's like a warning. Like, we'd prefer you not smoke. We'd prefer you not deal those drugs. But we're going to go look at this other thing because, the people have decided it's more important based on their whim. Most people don't understand the law, let's be honest. And I've documented this in class, for 10 years. I can understand why. I mean, why would anyone need to go to law school? Why would anyone need to pass the bar exam if it were simple, right? Not everybody can be a doctor. Not everybody can be a lawyer. Not everybody can be an accountant, right? You're kind of specializing. So the law has become way more complicated than these kind of easy stories. So you want to think about that gap. What does that really mean? Well, that means that most people don't benefit from the law. The people who understand it, right, mostly benefit. But those who don't, they're mostly kind of suffering as soon as they find out what the law really means. The other thing is there's massive corruption. Now, corruption is something that we measure in political science. So you can look at, Romania kind of tends to be the most corrupt of all the countries in the world. And there's really interesting reasons for that, actually, if you want to do that research. But, everyone's corrupt in the world, right? There's no country that's not corrupt. But, when it comes to law, that's the place where it can be the most corrupt. That's the easiest place to be corrupt. Because who's going to check on the laws? Who's going to come up and say, well, this law out of your 7,000 is a problem? So, it's not so easy to avoid corruption in that situation. And then, of course, human beings are not angels, right? Sometimes we have good days, sometimes we have bad days. Most of the time we just survive, right? We just eat, sleep, and hopefully work. So, you should be asking this question, like, so why have law at all? Well, this is not a great answer in my opinion, but it's passed along with each generation, and it's reapplied like a name, right? Why have your last name? I mean, who really cares? I mean, I know people who've changed their last name. Basically nothing happened. Why they felt like they needed to change it, who knows, right? But most people don't sit around thinking too much about, was that really my name 10 generations ago? Maybe not, who knows? so it just kind of gets passed down, and people don't really like think about it too much. It's not a real thing, right? It's not like a piece of property. It's not a gun. It's not gold, right? So people don't have to think too much about it, and so it makes it easy to accept. The other reason is, the haves come out ahead, and they win over the have-nots. So the haves obviously have a huge incentive to keep the law moving forward each generation. If the laws are benefiting their family, why would they go against them? So that puts a big burden on the have-nots, the people who are not benefiting, to try to change the law. If they don't understand the law, and they're not maybe so good at arguing why it should be changed, then you're going to see the difficulties. So this keeps a certain kind of control, right? It's not seamless control. It's not absolute control. It's a certain type of control. And this is typically called hegemony, which is the have-nots believe in the law as ideal, and so they follow the rules even when they're not good for them. Whereas elites, or the haves, tend to not follow the rules because they don't have to, because who's going to get them in trouble? In theory, it would be the have-nots, but if the have-nots are so busy trying to please the haves, then they're never going to keep the have-nots from running wild, right? And that's what corruption really is. So here's the trick, though. It's not a firm thing, right? What does this contradiction do? It alerts the have-nots that there's something wrong with the system. And so when you see equity or equality problems, what you see is the have-nots starting to realize that this system doesn't really make sense for them, and they're fighting back. Now, what are they fighting back with? The law, right? Or rights or power, all these different kind of concepts that were being used against them. That's what makes human beings super interesting. The experience of law helps people better understand how to form a society. It doesn't mean it's going to be a perfect society or a good society, but it starts to have this very dynamic kind of process in which people can start to fight back, to exercise their rights, and really, reinforces this concept, right? Now, law moves slow. So abduction as a logical process moves slow. But so does evolution, right? To go back to that biology professor, she was frustrated that students tend to see evolution as just mere change, meaning like the internet versus the telephone. But I would call that like a foundation, right? I'd call that like the first level in a 10-story building of understanding how evolution works. And so if you can start to understand this abduction process, then let's say this is the first level, second level, third level, fourth level. By the time you get here, right, you're going to start to understand. Now, I just want to close with my frustration, right? I just updated your participation grades. These are out of 10. So once you get to 10 on the participation in Blackboard, you will get an automatic boost of 10% as an A to your final grade. But I just want you to see, right? The grades are all over the place, right? So students complete work at their own leisure. That's one of the realities, the lived experience of working online. I'm A-okay with it. I'm not going to punish or penalize or take away points from students who do work at a different time than you do. I don't have any idea how everybody would do it at the same time. We're not in person. So that means that these main assignments are the ones that are going to determine your grade, because I took the time to try to sketch this out to see, okay, how's the best way that you're going to show me that you're starting to understand this abduction process. You're stopping thinking like an ordinary person, and you're starting the process of thinking like a lawyer. That's how this works. So let me just briefly explain, right? If you do all of the assignments, right? So you see a 6 and you only have 4 more to go, and you get your 10 points, you're going to get a final grade boost of 10 points. That means that if you did the same work as this person over here and they didn't do it, they'd get a B+, you'd get an A+, right? So the same thing would be if you get a C+, you'd probably get a B+ with the additional, right? It's hard to say that, right, without knowing all the details, because at the end of the day, right, this is a percentage-based system. and maybe I'm going to talk some shit. Unlike the rest of your professors, or some of them, I'm not sure they're actually weighing the points, or they're trusting Blackboard to do it, which I don't trust Blackboard. I'm going to use a calculator. You know, the idea here is that I really care about, I care about this assignment more than anything, to be honest with you, right? The letter to the judge, because this is where you can show me that you're understanding these concepts with something that's personal to you. And in the last 2 semesters, students have done really well with this assignment. So this is where I really want to put the majority of your weight. The final exam and the quiz are just making sure that you're keeping up with the concepts. And then I leave the extra 10% to help boost you. It is really technically only 5%, but I'm giving you a 5% boost on top of that 5%. So I want you to do well. It would be great if you would do all of the assignments, but that's not realistic for all students. So I don't want to put that pressure on you. The last thing would be just to think about the quiz. Now, it's, like I said, students have already taken it, so you can look at it ahead of time. So I'm not going to do a review, because that would be silly from my point of view. The first half is just, to be honest with you, stuff that you should already know. And if you don't know it, I've provided a resource where you can learn it real quick. And these are kind of basic facts of the legal system in the United States and in New York. But this is really where I'm trying to see, are you understanding that there are multiple points of view within the legal system, that there's not one point of view. That's what I want to see here, that you can see that there's not one human nature, and there's not one correct answer when it comes to law. And so there's going to be a series of answers that fit a pattern. And there's 3 to 4 different patterns that judges tend to follow. The other one is that I really want you to get this answer correct, so I'm going to tell you what the answer is. The 4th Amendment explicitly requires a warrant issued by a judge. It implies, or some people, I don't imply that, some people interpret it to mean that it implies reasonable suspicion. But it does not say reasonable suspicion as a requirement of a warrant, right? Probable cause is the requirement for a warrant. So reasonable suspicion is a legislative attempt or a positivist attempt, whereas a warrant issued by a judge is the natural law interpretation. So those are 2 already interpretations of one right that folks have, and that's the majority and the minority view. The 3rd view, if you're curious, is called the totality of the circumstances, which requires you to understand logic and math. If you're interested in that, I'd be more than happy to help you, and would give you extra credit for helping me think of some story problems that we could make for criminal justice students to better understand math and law. I probably did more than was necessary for this session, but I just, some of the requests from students are pretty intense, so I wanted to give you something. And then some of you are pretty lost, and so I wanted to just make life a little bit easier for you. It's kind of much simpler. And then I'll just kind of keep checking in with you over quizzes. I'm going to start up the, I said quizzes and I meant quiz and surveys. I'm going to start up the office hours so that we can start checking in with each other that way. And then anytime you want to talk to me, we can schedule a Zoom or talk over email, whichever is better for you. So that's all I have.